All right, this is what we're going to be taking you through this morning. I'm going to start with a bit of a focus on compliance issues. We've seen an increase in UK compliance action over the last year to 18 months. So I'm going to talk a little bit about that and some sort of key topics and points to bear in mind around that. One of which will be a focus on a particular aspect of right to work checks, and also going to talk a little bit about clawback agreements, partly because that's something that we've been getting a lot of questions about over the last couple of years since the immigration fees really started ratcheting up, but also because there have been some recent changes announced which are potentially relevant to the way in which we think about what fees can be clawed back from workers who we're sponsoring. Nishal's then going to step in and talk some more about compliance and UKVI compliance inspections in particular. Been a recent uptick in the number of pre-license checks. So Nishal's going to talk you through some of that. And then Nishal's also going to talk about some of the changes which were announced just last week relating to sponsorship of care workers and also salary thresholds in general. All right, well, what are we looking at then in terms of compliance activity from UKVI at the moment? Well, these two charts are sort of intended to illustrate that. Perhaps worth just explaining to begin with what happens, what the process is when UKVI decides to take compliance action against a sponsor. Usually this takes place after a compliance inspection, but it's not always the case. It might be that they carry out some remote checks or are made aware of some intelligence which leads them to have concerns about a sponsor's compliance record or ability to continue as a sponsor. And so the first step in overwhelming majority of cases is for UKVI to send the sponsor a letter suspending them from the register of sponsors. So we get a suspension letter. That letter sets out UKVI's concerns and gives the sponsor an opportunity to respond, explaining why, either UKVI are mistaken in their beliefs that they're non-compliant, or explain what steps they've taken to resolve any issues. So the first step is the suspension letter. Then we have 20 working days in which to respond. UKVI will then consider that. And if they're still not satisfied that the sponsor is compliant or able to comply, then we move on to a revocation. So they'll issue a second letter removing the sponsor from the register altogether. So what we can see on these charts, particularly if we focus on the one on the left, which relates to compliance activity taken against worker sponsors, so sponsors under the sort of work-based immigration category, skilled worker, global business and mobility, formerly intra-company transfer, what used to be referred to as the tier 2 categories. You can see that a fair amount of compliance activity in 2020. Then we had the pandemic. So generally these sort of letters are issued. There's a bit of a delay in terms of them being issued. So very little activity in 2021 as the sort of in the sort of aftermath of the pandemic. Things then started to increase a little bit in 2022 and then again in 2023. But look at what happened last year, and an absolutely massive jump in the amount of compliance activity, both in terms of suspension letters issued, but also following on from those, the revocation letters. You'll see that there is always a sort of a gap between suspensions and revocations. That's because, as you would hope, having considered representations from a sponsor or their representatives following the issuing of a suspension letter. They won't always go on and revoke the letter, the license. But you'll see, and we don't have the raw numbers here on the slide, but you can just see by looking at the bars, it's well over 50%. It's a good majority of those suspension letters do result in a revocation. We're sort of concerned today mostly with work-based or employment-based immigration, but just by way of comparison, I've included as well on the slide the activity against student sponsors, so independent schools, universities, private colleges, and we're talking about much lower numbers, but nevertheless, and that's primarily as a result of the fact that we have far fewer student sponsors than we do worker sponsors. There's now over 100,000 registered work sponsors. There's something around 1,000 student sponsors. So the numbers are, so we're talking about different orders of magnitude here, really. But yes, you can still see, as far as student sponsors are concerned, that following the lull during the pandemic, we've seen a far greater level of compliance activity against student sponsors as well. So those of you from schools, universities with an interest in the study side of things should also take note of that. I mentioned in my brief introduction that we're going to look at right to work checks. Well, one of the reasons for that is that this is something that we're finding UKVI increasingly focusing on when carrying out compliance inspections, particularly what we refer to as pre-license inspection. So where someone's applied for a license and UKVI carrying out an inspection before granting that license. And one of the things they're particularly interested in, under the sort of banner of whether the potential sponsor is or may be a threat to immigration control, using their language. One of the things they really want to see is that you've got a good handle on how you're conducting right to work checks. And we've certainly seen cases where even where there's been where there are robust processes in place now, as far as carrying out right to work checks are concerned, historical transgressions may still give UKVI concern or at least pause for thought before granting the license. And there's a particular aspect of the right to work checking regime that I wanted to focus on this morning, because I think that since we've moved to a system where far more checks are being done electronically, that one part of the process that is sometimes being overlooked is what's referred to sometimes as the imposter check. So it's all very well getting the relevant documents from the employee or prospective employee and seeing on those documents that that person does have the right to work. But are we then checking that the document we've presented with relates to the person who is presenting themselves to work, or you're thinking about making an offer to? And as I say, sometimes we've spoken with clients, we've been out to visit and review processes in delivering training. It seems that there's sometimes a bit of a sort of disconnect from that, which is sort of getting the digital record, be that a sort of copy of an e-visa through a share code, and we're seeing, oh yes, okay, well we have the document, that looks broadly like the person who I spoke with a couple of months ago, so that's fine, we'll put that on their file and on we go. It's really, really important that within that process you also build in a regime for checking that the photograph on that document relates to the person who's presenting themselves to work. The reason it's become more of an issue recently, as I said, is because we're doing more and more digital checks now, which does allow for an element of remoteness. When we're presented with physical documents, and it wasn't all that long ago that all that somebody would be able to present would be physical documents, where someone comes into your offices with their passport, the imposter check just becomes a natural process of that. Look at their passport, look at the individual, yes, I can see that they're the same. Both documents are in front of me, and there we go. So there's various bits of guidance in the Home Office's guide for employers on conducting right to work checks. But yeah, quite simply, all we need to do is just take a sense check, essentially compare the person's appearance with their photograph. And sometimes you might need to apply a bit of a sort of mental calculation. If the passport's old, for example, you may be aware we can accept expired British passports. So there's a possibility that the passport is more than 10 years old, and depending on the person's age, those last 10+ years might not have been kind to them. So you might need to apply a bit of a mental algorithm, I suppose, to that, sort of just to see whether the photograph is still consistent with their appearance. The other thing we can do when we have a physical document in front of us, of course, is to look for any obvious signs of tampering. So on older passports, there's sort of film of acetate over the photograph, for example. So is that sort of peeling away, that sort of thing. So we can look for that. It is possible to remotely verify somebody's identity. So the guidance makes it quite clear that we can have a video call with somebody to check their identity. If we're checking a physical document, such as a passport, we still need that passport in front of us. So they will have needed to have sent that passport to us, or otherwise have it in front of us, and then we can have a video call with them. So that's not always terribly practical. But if it's somebody with a visa and you've got their share code, so you're able to check their e-visa, then you can have the e-visa on one half of your screen and a video call with them in order to compare their photograph and their appearance. Similarly, if you're an organization which is using an identity service provider, so which can be used to check British and Irish passports, again, you can get the report from the IDSP and compare that with the person's appearance over a video call rather than having to call them in. So there is that possibility for remote verification, but do bear in mind, if it's a physical document that you're looking at, such as a passport, then you need that physical document in front of you rather than a copy. So I suppose the point really I'm trying to get across is to make sure that this process for imposter checks is built into your recruitment and onboarding process. Think about how that gets done. Don't just sort of assume that it will happen because you've sort of got a line in a checklist which says right to work checks. I would also sort of go a bit beyond that and make sure it sort of spells out correctly that you need to check it, firstly the document and then also the person's appearance. And I think best practice is to make a record of how the imposter check was conducted, the date on which it took place. Remember that the checks need to take place before employment starts. So again, making sure that's built into your process, ideally before their first day. But if it has to happen, if the check has to take place on their first day, it has to happen before employment commences. So again, that needs to be built into the process somehow. We offer plenty of, sort of training and guidance and advice on right to work checks. One of the ways that we do that is through our HR and employment law for managers e-learning module. Covers lots and lots of HR topics, but there is a module on right to work checks. So if that's something that you would be interested in, we have a poll on the screen now, so please let us know, and one of the team will get back to you to discuss that with you. In case, hopefully it doesn't, well, I do the module on right to work checks. So if you're not enjoying this webinar, you probably won't want to sign up. But otherwise, do let us know if that's something that you might be interested in. Just wait a couple of moments. Or I think we can move on while the poll is carrying on. Okay, let's move on. Okay, so the last sort of substantive point I was going to talk to you about was clawback agreements. So again, this is something that we're seeing a lot of questions about over the last few years. In recent years, the costs of sponsoring somebody, particularly under the skilled worker immigration category, have, ratcheted up pretty significantly. And as it says on the slide, if it's somebody coming to the UK with their family, a family of 4, applying for 5-year skilled worker visas, looking at fees of over £25,000, a significant amount of money, and particularly for somebody who may be coming from a less affluent part of the world. Those fees are made up of some various bits. I'm going to use the technical jargon. So various elements of those fees. There's fees that are paid at the point where you sponsor the individual, where you assign a certificate of sponsorship. There's a COS assignment fee. There's also an immigration skills charge, which varies depending on the individual's particular circumstances, but primarily on the size of the business or whether or not you're a charity. And then we've got the visa application fees, and on top of which there's an immigration health surcharge. So various elements to those fees, and over time, sponsors have and clients have developed various different ways in which they will pay some or all of those, or seek to recover some or all of those fees, depending on what their arrangements are with those particular workers. There are some parts of those, some elements of those payments, which it's quite clear from the sponsor guidance, particularly since 31st of December just gone, which the sponsor is prohibited from passing on. And if those fees are passed on to the sponsored workers in any way, then that's a serious breach of your sponsor guidance and leaves you liable to having your sponsor license revoked. So you cannot pass on the COS fee. It's only £239. Come on, you can suck that one up. There is also the immigration skills charge, which you are not prohibited from passing on. That has been determined by the Home Office as being something which the employer has to pay, and which sort of is part of the costs of sponsorship. That can be significant if you're a large business. That's £1,000 per year, but it's not payable on an annual basis. You pay it all up front at the point where you decide to sponsor somebody. So that fee could be up to £5,000 if you're sponsoring them for the maximum possible period, but you cannot pass that on even by way of a clawback or anything like that. One of the reasons for that is that if the person does leave their employment early, then actually you get a prorated refund for the unused proportion of the skills charge, for example. So if you sponsor somebody for 5 years, they leave after 12 months, you'd get 4/5 of the payment that you'd made refunded to you automatically by UKVI. So there's no so on that basis, it's not sort of the end of the world if you can't recover that. We do have, as I mentioned at the beginning, last week UKVI announced some changes to the immigration rules. Oh, sorry. Before I go on to that, let's just finish that previous thought. So we can't pass on the COS fee, we can't pass on the health surcharge, so we can't pass on the skills charge. But some employers will pay the health surcharge, will pay the visa application fees, and then come to an agreement with their employees, either to repay them, so it's effectively a loan repaid through payroll, or we don't ask for the money back if the individual stays with us for a particular period of time. But if they do leave within a particular period of time, 2-3 years, for example, then they will pay back some or maybe even all of the those fees that the employer has paid. So that's where we see clawback agreements becoming more and more prevalent in this sort of arena. Bit of uncertainty around all of that now, though. We've had some rules published last week, and they say now when someone's applying for their skilled worker visa, that any deductions from salary or repayments of loans, etc., that have to be made by the sponsored worker to their employer will be subtracted from the sponsored worker's salary. And so if that person's salary is sort of close to the threshold, then that may well drop them below that threshold and mean that they don't actually qualify for a skilled worker visa after all. Now, we're seeking some clarification from the Home Office on these points, because that seems to go against what the sponsor guidance suggests, which suggests that you can't recover the skills charge or the COS fee, but the health surcharge and the visa application fees can be recovered. But as things stand, from these rules that were published last week and which are due to come into force on the 9th of April, it seems that that might no longer be permissible. The new rule does say that there's an exception where there's a clawback agreement, for example, which covers other sorts of costs. So, and it, as I said on the slide, an additional benefits offer which the applicant has a genuine choice whether to take up, for example, salary sacrifice arrangements. So those can be, those won't be discounted from the summary, but potentially any immigration costs that you've paid under this new rule, it seems, will be deducted from the salary package that's on offer. And if, as I said, if the pay that you've offered them, if their certificate of sponsorship salary is at or close to the threshold which is required in order to meet the salary threshold requirements, then there's potentially a problem. So do watch this space on that one. As I say, we are raising queries with the Home Office to try and sort of clarify whether that interpretation is correct or not, and hopefully we'll get something before the 9th of April, and we'll certainly try and put out some publicity, an article or what have you, when we have some clarification. But if you are using clawbacks, do watch out for that. Okay, I can see there's been plenty of questions both in the Q&A and also the chat. I have to say, first of all, if you have questions that you'd like us to answer at the end, if you could pop them in the Q&A box rather than the chat box, then that way we'll make sure we come to them. Otherwise, we might miss them if they're in the chat. Otherwise, though, that's the end of me for the moment. I'll be back to do the Q&A at the end, but in the meantime, I'll hand over to Nishil. Thanks.
Thanks, Tom. So as Tom has been saying, compliance is at the top of the Home Office agenda at the moment. And one of the areas that they are looking at is the sponsor license application process. And what we're finding is at the moment, sponsor license applications, the approval rate is around 60%. And that is a massive decrease from 2 years ago when the approval rate was around 80%. So why is that the case? It's because the Home Office are scrutinizing every application that they're receiving. So once the application has been submitted to the Home Office with the mandatory supporting documents, the Home Office are asking for further information from the business in order to ascertain whether to grant the business a sponsor license or not. Now, these questions that are being asked are very similar to what are being asked and if someone was being audited once they have a sponsor license as well. So these questions are all particularly relevant. So the Home Office are sending an email to the businesses once they've submitted the sponsor license for further information. And this further information can include things like the personal details of all their employees, which include the name, date of birth, and nationality, and usually the organization chart. The evidence of all the right to work checks that they've completed on all their current employees till date. I've had a circumstance where I've had a business come to me and they've applied for a sponsor license, and unfortunately it has been refused because the Home Office were not satisfied of their right to work checks. And what happened in this instance was that they had a migrant employee that they had decided to employ. And when the Home Office asked for this information, they had actually provided the share code from the date that the Home Office asked for the information. And the Home Office could see that the share code was logged in at the point of the Home Office had actually requested the information. And it wasn't actually at the point of when the individual had previously started their work. So the Home Office could already see there was an inconsistency between those two dates. And they did not believe that that business was conducting their right to work checks correctly. So it's really important that these right to work checks are being completed correctly, because the Home Office are checking everything. The other documents and information that the Home Office are asking for are contracts of employment for all current employees, and also draft contracts for any future roles that the business are looking to assign certificate sponsorships to. And that is to ascertain, firstly, that the salary that they're going to be paying this sponsored worker is in line with the salary that is being paid to similar workers within the business, and that there is not a massive uplift just in order to sponsor this individual. They've also asked for bank statements for the last 3 months, and that is just to ensure that the business has got sufficient funds to be able to pay the salaries for these employees. There have been a number of cases within the news where a business hasn't been paying the employees the correct salary level, even though they've said it on the certificate of sponsorship. When the Home Office have viewed the payslips of the employees, they have seen that they've not been paid what they're supposed to be paid. And that can cause issues with having the Home Office audit the business and then a revocation of the sponsor license, which could not only affect the business, but also the employees on that sponsor license. The Home Office have also asked for annual leave and other absences to ensure that where you have a sponsored worker, you're aware of their whereabouts and you know exactly where they are, and you've got a tracking mechanism in order to do that. That you are aware of any immigration status of your employee and you know how to monitor the length of the visas, and that includes monitoring their expiry dates. You need to provide supporting information to the Home Office regards to any pension schemes that the business offers to eligible employees. Passports or other proof of ID for current employees, so that's just like the right to work checks. And finally, it's copies of all the current official client contracts, and that includes the start date, the volume of work required, and the resourcing requirements. So again, the Home Office are looking at whether there is actually a genuine role for the business, and they want to see how much work the business is generating and whether there is actually a genuine need to have an individual within the organization. So something that I've had in the past is that the Home Office wanted to see what contracts they have in place with various clients in order to show that there is actually a business need to have an additional person within their organization. So it's just really important that whenever you're submitting information to the Home Office, that it is clear and consistent, and that you have really shown that it is a genuine role that you're looking to hire for. Next slide, please. Once you send all those documents to the Home Office, then you may be invited for a pre-license interview to discuss all the information and documents that you provided to the Home Office. And this pre-license interview is very similar to a post-license interview, in which the Home Office would seek all the same information in order to quantify whether, firstly, you're meeting your sponsor license regulations, and secondly, whether you are doing your right to work checks, you've got the processes and practices in place to prevent illegal working. So what I'd like to do now is go through some of those questions that you typically asked at an interview. So a business would be asked to provide a general background on their business. And that would include things like when the business was incorporated, how the business has grown within the various years, who their competitors are, what kind of goods and services they're providing. They would also want to know why you're applying for a sponsor license. So exactly how you've maybe struggled to recruit from the local workforce and where you've needed to hire from outside of the UK, and that's the need for having a sponsor license. They want to know your approximate recent annual turnover. And again, that is just to do with how you're going to be paying these sponsored workers within the UK. they'll be asking you how you're going to be paying your sponsored workers, so whether they'll be enrolled within your payroll. And they want to see all this evidence as well. So if you are audited in person, they may want to ask you to share all the data with them to say, okay, this is the processes that we have in place in how we're paying our staff. Or if it's an online audit, they might want to see that online through showing where you need to show them through your systems. I've covered this as well. So if they need, if you have contracted work in place at the moment, so as I said before, the Home Office need to see that there is actually genuine employment. There is actually work available for that sponsored worker in the UK. Within the financial areas, they want to know how salaries will be maintained should financials forecasts not be accurate. They want to know evidence of checks that have been undertaken for any migrant workers that have been employed. So evidence of your right to work checks. They want to know how you conduct your right to work checks. They want to know when you conduct your right to work checks and how you continue to monitor individuals who are on visas. What practices and mechanisms do you have in place to do that? And that falls into the HR systems that you have in place. And that can include things like the right to work checks, your absence schedules, different policies for business visitor arrangements, for example. So the Home Office do want to see all this information in order to then qualify whether they can grant an organization a sponsor license or not. Unfortunately, at the moment, what we're seeing is that the Home Office the mentality is that they're looking to refuse. So what I would urge businesses is that when they are applying for their sponsor license, make sure that you're diligent with all the information that you're sending to the Home Office, all the documents, and within the interview, all the answers that you're giving them, because they're going to be checking on everything and find out whether there are any discrepancies. If there are discrepancies with what you're saying in an interview to the documents that you are providing the Home Office, then that can cause a refusal. Next slide, please. There are other considerations that would need to be taking place when you're applying for a sponsor license. So when you're applying for a sponsor license, you need to have at least one level 1 user within that sponsor license. And that level 1 user is able to log into the sponsor management system and be able to understand which individuals are being sponsored under the sponsor license. And they're aware of their responsibilities as well in order to update the Home Office if there are any changes to the employee's circumstances or any changes to the sponsor's circumstances. So for example, if you change your work address, that you need to update the Home Office within the 10 working days. So you must nominate at least one level user who is an employee, director, or partner, and that level 1 user must be permanently based in the UK and either hold British nationality or settlement status. Now, previously, a legal representative could be added on to the sponsor license as an additional level 1 user. Now, the Home Office has actually taken that away. So when you're applying for a sponsor license, you can only have one level 1 user who is an employee of the organization. You're not able to put any legal representative as a level 1 user at that point. Once the sponsor license has been granted, it's at that point that the level 1 user can add the legal representative to this sponsor license as a level 1 user. So that's when they'll be able to be granted their level 1 user access. You may have heard in murmurings about a self-sponsorship visa, and the Home Office have been attuned to this. And what they've been finding is that businesses have been just starting in the UK, and what's been happening is that the owner has been coming into the UK under that new business, and they've been able to get sponsored under that business. So it was kind of very similar to a sole representative visa, but in a different way in terms of that the owner would be sponsored under the skilled worker visa. So the Home Office are very suspect of these kind of businesses. And if you are a pre-revenue company or a startup, so a business that's trading for less than 18 months, you would expect, you are going to expect now extra scrutiny on your sponsor license applications. And that would include things like facing long delays and maybe refusals on your sponsor license application if the Home Office do not feel that it is a genuine business need for this sponsored worker to come to the UK. They do want to see what business transactions that have been occurring within the UK and that business is actually actively trading at that time. So they may want to see contracts, invoices, to show that actually it is turning around money. Another part is they want to see the bank statements. So they want to see exactly how much money the business is generating. And they want to see how the business is going to be paying the salaries of the sponsored worker that's coming to the UK. Now, the Home Office does need to be satisfied that the role is genuine and it's not created simply as a means to enable an owner or a shareholder to come to the UK. So it has to be a genuine business need. Once the sponsor license has been granted, what we're also finding at the moment is that once the skilled worker is applying for their visa application, once they've applied, they're actually now being interviewed as part of the application process. And what I've found is that sectors within the hospitality, entertainment, and the construction sector, and also the restaurant trade, those are the individuals that I've found that have been interviewed the most. And what's been happening is that once the application has been submitted to the Home Office would then invite the worker for an interview. And at the interview, the worker would be asked questions like, where is your work address of your new UK work? What's your job title? What sort of job role are you doing? Who is your line manager? Where will you be where are you looking to stay in the UK? How will you be commuting to your work? So they do want to, so they are really scrutinizing even skilled worker visa applications now. And I have seen individuals come to me with skilled worker visa refusals because they do not believe that that individual who is going to be on the skilled worker visa understands that they are going to be sponsored in the UK and that there is a genuine job role for them within the UK. So again, that is just something really to bear in mind in terms of when you're applying for a sponsor license or even applying for a skilled worker visa application. These are all the things that the Home Office are considering at the moment. Next slide. So we have seen rule changes which were announced last week, which are going to be taking in place from the 9th of April and from the 9th of April next month. So the first change is with regards to care workers. Now, the Home Office have found that there are a number of care workers in the UK already with skilled worker visas. And unfortunately, some of these care workers are in limbo in the UK because they've come here as a care worker, but unfortunately, their sponsor has either lost their sponsor license or they've been made redundant. And so they are in limbo. So what the Home Office would like to do is they've sort of added this pool of displaced care workers and they've made them available to care providers via regional, sub-regional partnerships. And what they've asked businesses within this sector is that they want them to look at these pool of workers first before you're able to sponsor a new hire to work in the UK. So firstly, you must provide evidence that you've actually tried to recruit from this pool of workers by providing a confirmation from the regional, sub-regional partnerships. And once you've got that confirmation, then you can then apply for a skilled worker visa for that individual to come as a care worker. Now, this new regime for care workers only applies to work in England. So it doesn't apply for workers who are going to be working in Wales, Northern Ireland, Scotland. So it's just an England new policy for care workers. Another rule change is around the skilled worker visa. So the minimum salary for the skilled worker visa will be increased from 23,200 per year, which is £11.90 per hour, to £25,000 per year, and that's or £12.82 per hour. There's also going to be updates to the going rates for occupations in healthcare and education. And those are standard annual rates that usually happen within that sector anyway. So that's an expected change. You may have seen another slight change within the immigration rules as well, in which Trinidad and Tobago have now been added to the visa national list. So individuals who are coming from Trinidad and Tobago who want to visit the UK will need to apply for a visit visa to come to the UK. And that is a result of a number of asylum claims that have been made over the last year or so. Perfect. So now we've sort of spoken about the rule change compliance. Would I like to hand it over to any questions?
Thanks, Nishal. Yeah, plenty of questions come in this morning. So let's take it from the top. Actually, a question that came in quite early on, but actually probably quite relevant to the stuff you've just been talking about, whether the Home Office are targeting any particular sectors for sponsor compliance activity, or if it's just an increase in this activity across the board.
I would say it is generally across the board, but what I found in particular, especially with the skilled worker visa interviews, it is being around the construction sector, the hospitality, the restaurant sector.
Yeah. And those, as you said, pre-revenue companies as well. They all seem to be.
That's right.
Both at pre-license stage and post-license, right?
So Tom, I've got one from you. So it's so when accepting older passport, is there a limit on how out of date those passports should be, or is it just that the person's experience looks more or less the same?
Yeah, it's that really. It's just sort of applying your mind to whether, looking at how old the photograph is and deciding whether that's still consistent with the person's appearance. One thing I didn't mention earlier, there was a relatively minor change to the guidance on right to work checks, which says that you're no longer able to, you can accept an expired passport, but you can't accept a cancelled passport. So a cancelled passport is one where they've, to use the terminology, clipped the corners of the passport. So normally when you get a new passport, your old one is returned, but they've cut off the corner. So you can't use the clipped or the cancelled passport. You'd have to use the new one in those circumstances. So if someone tries to present you with a cancelled passport, you're no longer able to use that. But yeah, otherwise you can accept an old passport, provided you do that bit of sort of mental gymnastics and work out whether the photograph is still consistent with the person's appearance. Next question, could go to either of us really. I have a skilled worker that we're sponsoring who's now been approved, who's now received indefinite leave to remain. What are my obligations, as I cannot see how to update this on the sponsor management system? Take that one, Nish.
Yeah, so there's nothing specifically to do on the sponsor management system for these workers, but you just have to carry out your normal right to work checks to show that that individual has now got the indefinite leave to remain and that you've satisfied that.
I'd say for completeness, that's technically a change in their immigration status, and you're no longer sponsoring them. So I'd say probably just add best practice would probably be to report that as the fact that you're no longer sponsoring them because they've been granted indefinite leave to remain. Next question. It's probably about right to work checks again. Is there a specific form of words that you need to use following a check? For example, I can confirm that I've checked the appearance and verified that this is a true likeness. Do you need to record that it was an in-person check? I don't think the guidance is explicit on that. I'd say best practice would be to do that. There are suggested forms of words within the guidance on conducting right to work checks. You might want to verify that, but yeah, otherwise that form of words that's being suggested would be pretty, not too far off what would be expected. Next question. What should employers who already offer an interest-free loan scheme for visas and IHS fees do in this period of uncertainty? Shall I take that one?
Yeah.
Yeah, hard to know. I mean, I think that if you've the new rules that I discussed earlier apply to applications. So it's what they will consider when the application's been made. So I think on that basis, I'm fairly safe in saying that for people who are already sponsored, these rules don't apply. So it's anybody who you're going to be sponsoring after the 9th of April that we need to get some certainty over. So I think if you've already entered into the loan agreements, if you've already signed people up to clawback agreements, I don't think there's going to be any sort of retroactivity as far as this new rule is concerned, because as I say, it applies to their assessment of the visa application rather than your ongoing duties. Unless they haven't announced that they're going to do this, but unless they update the sponsor guidance. But again, watch this space and we'll sort of update when we can. Okay, that one I think I've already answered. Oh, and just to clarify, so repayment of surcharges, taking them below the salary threshold. What if you've loaned the employee money for their dependents as well? I think it would be, you know, all of that. If you've loaned someone, 15,000 or whatever for their visa application fees, and that includes their dependents, then potentially the phrasing that we're sort of looking at and sort of wondering whether there's some wiggle room around is where it relates to whether there's a genuine choice offered to the sponsored worker. So if you've said, look, you can take the loan or you can sort out your own loan or something like that, then that might provide us with some wiggle room. But again, I'm afraid there's just too much uncertainty. The way they're drafted isn't helpful, and we'll be trying to get some clarity on that. What next? If someone has indefinite leave to remain evidenced by stamping their passports and their NTL visa is currently in process, can we continue to employ this person? Well, that's quite a tricky one, because it will depend whether you've got a statutory excuse in the first place. I would say, if the only evidence you've ever seen, if they're an existing employee and the only evidence you've ever seen was indefinitely stamped in an old passport, then it might be, depending on when they started work, that you never had a statutory excuse in the first place. I think that one's probably a bit fiddly and fact specific. So I'd say, you know, maybe get in contact with us outside of this webinar, because, as I say, that you know, it's not safe to sort of give you an answer that may not be correct based on your particular circumstances. Okay, Nishant. How are agencies managing to sponsor workers? How do they know that the applicants are going to meet the salary threshold?
I think, I mean, probably one of the things that they're looking at is, you know, that you have to look at the pay slips and the payroll data that you have of that individual, and that's what the Home Office are going to be looking at, whether they've been sponsored correctly under the correct salary thresholds.
I think the point here is the question is being asked about agencies, and agencies aren't permitted, employment agencies are not permitted to sponsor workers unless they will be working specifically within the employment business itself. So if there are agencies out there who are offering to you sponsored workers workers who are on a skilled worker visa sponsored by the agency, somehow the agency have managed to breach the rules, breach the guidance. So I'd tread very carefully, because it might be that the person doesn't actually have a they might have a visa, but they might be in breach of the terms of that visa. So do tread carefully if that's what you're being offered. Agencies shouldn't be able to sponsor anybody, and their visas should have been refused if they've applied on that basis. Nishal, there's a question about certifying maintenance. Do you want to pick that one up?
Yeah, I mean, I haven't seen that in terms of checking the certified maintenance. I think the reason why is that they just want to make sure that they're not sort of using public funds in order to, you know, to live and stay within the UK. So I think I haven't seen anything in terms of asking anything specifically for workers. I don't know whether you've got any other thoughts on that, Tom. No.
No. All right. Back to it. So if the salary deduction taken from net pay, does this still reduce the qualifying salary amount? Pass. Don't know. I mean, the salary thresholds, unskilled worker look at gross salary. I suppose UKVI would, as Nishal said earlier, look at pay slips to see whether the sponsor is paying the required salary threshold. But if you're deducting from net rather than gross salary, I don't know whether that's a way around these potential new rules. Again, we're just going to have to try and get some clarification from UKVI and, you know, come back on all of these sorts of points. Question here, how does the 9th of April rule change impact on people being put on national pay scales, e.g. teachers? And then I think there was a related question further down, yes, as to whether someone who's currently on a skilled worker visa, whether we need to increase their salary once these new salary thresholds come in. But that's not required, is it? You know, the salary that you put on their COS is the salary you need to pay them. But when you come to sponsor them again, you'd need to increase the salary so that it meets the national pay scales at that time. Any other questions jumping out at you, Nish? Another question on oh, go on, sorry.
Yeah, so I think, yeah, it's an interesting question with regards to retrospective checks that are being picked up due to historical issues picked up via audit. So does having appropriate checks and audit processes in place reassure that historical non-compliance has been identified and addressed? And what I've found is that the Home Office they are open to working with businesses to make sure that they do have the new practices and processes in place, so that if there are issues historically, that those issues have been addressed, and they would be happy that, you know, that the processes have changed to ensure that that never happens again. So I have seen that the Home Office have taken those kind of things favorably.
Okay. Right. Thank you. Oh gosh, such a lot of questions. Okay, when we do a share code check or use a digital identity service provider, IDSP, can we ask the interviewer, a member of our staff, to verify the photos from those checks? I would say that you can, but I would prefer that they do that live. So when they have the interview, I suppose in most cases they probably don't have the e-visa or the IDSP output at that time, and I would prefer don't think it's really explicit in the guidance, but I think, yeah, the preference, the best practice would be to actually have the e-visa or the IDSP report in front of them while interviewing, either via either remotely or in person, so that you're actually comparing the things side by side rather than sort of having to remember what the person looked like in the interview. So yeah, I think that would be my preference there. Try and fit in a couple more questions. When providing a new COS for a visa extension, should the start date on the new COS be the date after the current COS expires or the date after the current visa expiry? I think the guidance says after the current visa expiry.
These
right?
visa expiry, yeah, that's right. Yeah.
Yeah. Okay. One. Do we need to conduct a follow-up right to work check on pre-settled status holders under the EUSS? The guidance states it's not required. However, a pre-settled status is still a time-limited type of visa. No, I think that's right. I think the guidance now does say you don't need to check people with pre-settled status again. So yeah, I think that's the answer to that one. Right. I've got it as being 11 o'clock. I'm sorry, there were a lot of questions, and I'm afraid we didn't get round to all of them. If there is anything burning, any burning questions that you desperately need an answer to, do feel free to contact either Nishal or myself. Or look, there we go. Those are our contact details. So please do feel free to get in touch, drop us a line, and we can endeavour to respond to those questions then. Or indeed, if there's any other support that you think you might need. Oh, sorry, the feedback polls popped up. So yeah, if you wouldn't mind filling that in, that would be very, very, very helpful. But yes, yeah, if there is any additional support that you think you might need from an immigration perspective, please don't ask us to help with an unfair dismissal claim. Our colleagues can help with that. Nishal and I are not the people to speak to about those. But otherwise, yeah, any immigration assistance that you or your business might need, do feel free to get in touch. We'll be very happy to discuss that with you. So otherwise, I think that brings us to a close. Thank you very much for attending. Thank you for all of your questions. I do apologise that we didn't get around to answering them all, but I do hope that nevertheless you found this morning's session helpful. Thanks very much again.
Thank you.